So it is 2:15. I think we're ready to start our next session. So this session is a bit of a free-for-all for your questions, whether they're from earlier sessions or other questions you may have based on your own board experiences. Please let us know what you think of this format. Having about an entire Q&A session. Yeah, portion of the session. So again, a quick reminder, this is kind of how it works. You can open the chat using these functions. We don't really have a way to turn off mics for those participating. There, you may or may not see there's almost 100 people in the room, and it would just get a little unruly if everybody started talking at once. So we're gonna keep things to the chat. Hopefully, hopefully that's all right for everybody. So let's see. So I do have. It looks like Stephanie already answered one of the questions from earlier. I was going to say, since Stephanie ran a little bit over, I've got a couple questions. The one that's currently in the chat, you can all read as was one of them. But yeah, I figured we could maybe start there. But actually, really quick, let's see. Let's see. I saw Carol and Steve Buckley were present. I don't see them. I see Stephanie. So I don't know if so we've got Steve Buckley from earlier. He was our first presenter. He's the head of legal service counsel at NHMA.
Brendan,
And
can you hear me?
I can hear you. Yes, I can't see you. Are you
Well, I
let's
don't
see.
seem to be able to turn my camera on. Do you have control of that?
Let's see. You should be able to. I wonder I wonder if maybe your software is not playing nicely with Teams or something. If you don't mind, you could keep it off, or you could try logging off and logging back on again. That may work.
I don't dare do that. I think I'll
Okay,
just leave
okay,
it. Uh,
that's
my
that's
my
fair.
internet is too flaky sometimes.
That's all right. Well, how about this too? You could use the raise hand feature if you had a point that you wanted to make, or if you wanted to answer a question, and I can
Okay.
keep as a sort of a plan B if we can't see you.
Okay.
Does
That
that
would
sound
work.
acceptable?
Sure.
All right.
Yes.
Cool.
Thank you.
Yeah, no problem. Yeah, thank you so much for being here. And then Steve is Steve back? Steve, I saw him.
I am here.
Ah, there we go. All right. Excellent. All right, we got everybody. Perfect. All right. Thanks everybody for bearing with us while we, work through the technical stuff. Excellent. All right. Well, let's start with a couple of these questions from Stephanie's previous session. So meeting versus hearing clarification. A previously approved subdivision plan requires a minor administrative correction. Would that require a hearing, or can the corrected plan be reapproved in a meeting? So that's a question for Stephanie. Open here. You're muted also, Stephanie.
Thanks. Sorry, just saw that.
Ah.
Sorry. Like any good attorney says, it depends. It depends on what your regulations say. You can have administrative changes done through staff. But I don't think you would really need to go back and do a new public hearing, but unless your regulations say that. So if it's something that you're supposed to have, a minor administrative change, we added 5% more green space than what we were approved for. Depending on what your regulations say, you wouldn't have to go back to a public hearing for that. Your regulations could give you a certain threshold of administrative adjustments, just as long as the board chair or the board is aware of it.
All right. And then the next question, Stephanie, I'm sorry, Carol, did you have something you wanted to add?
No, no, I didn't.
Okay. Oh,
Thank
sorry.
you.
I saw your thing light up a little bit. All right, Stephanie, again. So you did actually answer this question, but somebody sort of missed it about waivers. So can a waiver be temporary? For example, 2 years of overhead utilities will be allowed until underground can be installed, as an example.
I would say, yeah, again, that would be something that, if you're check with your town attorney to make sure that you can legally do that. But I would think that if there's a deadline and again, working with the applicant, to do that, and maybe to get enough houses in, then you go underground. But I would consider that something that you could waive as long as you're kept track of it and it's enforced.
Okay, great. And then last question, because you answered one of them in the chat already. And this is, does the written decision have to be separate from the meeting minutes? So I think this is in regards to, yeah, the decision, the conditions that the planning board is putting on a project.
Yes, yep. They can be in the minutes, like I used to template it out and put conditions of approval in the minutes and just copy those and put them in the template, put them in the notice of decision, but they do have to be separate. You can't just refer to the minutes. It has to be a separate notice of decision.
All right, excellent. All right, so those were the last of kind of the questions from Stephanie's session that went from 12:45 to 2. And now we've got some kind of broader questions that have popped up, throughout the day that either didn't get answered earlier or somebody put them in the chat during a break. So this is kind of a little more free flow. So I think Steven is probably, or Steve Buckley is probably probably want to jump in on some of these as well. So I'll just start kind of rolling down the list from the top. So the first question is, what about roles of planning boards that don't have master plans? And this one was answered earlier, but we've had a few questions about this that they've come up a few times, and Stephanie kind of answered this a little bit in the previous one. I think Laura talked about it, and I think Steve also talked about it as well. So Steve, if you don't mind, maybe going over this one more time. So then they continue. Our town has a planning board, but no master plan. Is it mandatory that every municipality have a master plan?
Well, you have to have a master plan if you want a zoning ordinance, but there are towns that just have a planning board with authority to approve subdivisions, and so they have to craft subdivision regulations, which are really not designed to deal with all the zoning issues that a subdivision would do, but they still have to approve the division of land. And so they're probably somewhat constrained as to the level of regulatory authority they have, maybe something to do with streets, uh, line of sight for entrance, maybe driveways, but not a lot of subdivision regulation that goes on if you have no zoning ordinance. So I think that's just, there are towns, again, that only have a planning board with subdivision authority with no zoning ordinance. But you don't have to have a master plan. I mean, it's kind of hard to know where you're going if you don't know how to get there, and your master plan is really designed to do that.
Yeah, excellent. And I believe I remember, I think Laura Spector Morgan said that, a master plan could be 2 pages, or it could be 50 or 100 pages. It could be as detailed as anybody wants. So that's great. Great point. Let's see. So the next question's a bit of a long one. So let's see, she's asking, I am wondering if the short-term rentals owe any taxes to the town/cities for the meals and rooms tax. Another question is, so there's a couple questions. So another question is, are residents on private roads with abutters on the same road allowed to use their homes as short-term rentals? And then the last question, is there any way a town can have some type of oversight to know whom or how many are renting a residence?
So short-term rentals are required to pay rooms and meals tax. That was an accommodation reached with some of these platforms, Airbnb, VRBO, and so there is a process where, under certain circumstances, I can't quote you the exact statute there, where there's a rooms and meals tax applied, has to be paid by the platform through the owner. So that does apply. You're gonna have to repeat the other parts of the question, Brendan. I can't see them
Sure.
in the chat.
Oh, that's all right. Yeah, I could also add them to the chat as well. So the second part of that question was, are residents on private roads with abutters on the same road allowed to use their homes for short-term rentals?
Okay. Well, so they're on a private road. So presumably they got permission to build on a private road, and they have presumably some kind of agreement amongst the property owners. Because when you are building on a private road, you had to get approval under RSA 674-41 to have a structure built on something less than a Class 5 road. That agreement normally has a statement that you have the obligation to maintain that road, and so there is a statute that really addresses the need for those who are residing on a private road to have a common understanding of who's going to maintain the road, how the road is going to be maintained, consistent with the agreement they made with the town that it's their duty to do so. So to the extent, I suppose, the short-term rental, assuming it's not a zoning issue in terms of some other regulatory control the town has over short-term rentals as a permitted use, which is separate from this issue, there may be some need to have a common understanding amongst all those on the private road that yes, these activities, which may generate more traffic, are accepted or permitted or allowed. But that would be that agreement amongst those private landowners over the use and maintenance of that road, which again probably derived from their permission to be allowed to build or have a house on something less than a Class 5 road under 674-41.
All right, and then the last part of that question is there any way a town can have some type of oversight to know whom or how many are renting a residence?
So there are a number of towns that have procedures whereby the use is permitted, but it's subject to a licensure by the select board office. So you have to get permission from the select board to have the short-term rental, and you have to be licensed. Insofar as how that licensing procedures, as I've seen them be implemented by a number of towns, it wouldn't typically include, you have to, I suppose it'd be sort of like checking into a hotel, you got to sign in and we got to know who you are. You're going to maybe got to take your passport from you or those kind of things. Those are not really activities towns would do. It's typically just a licensure process where they have to get a license every year and pay a fee to the town, maybe get an inspection. But I don't think that kind of regulatory oversight over every guest at the Airbnb would be within the realm of what towns would want to do. It'd be a kind of cumbersome process. So I don't think that's really the type of regulations towns should be engaged in with short-term rentals. Licensing, yes, and or whether the use is permitted by zoning, those are appropriate mechanisms for towns to have for short-term rentals.
All right. And let's see. So the next question I've got it. I'm going to put it in the chat there. So this was from somebody earlier. They said the word is out amongst developers that cities can no longer require sprinklers in 3 to 4 family units, subject to some troublesome wording of the statute that can make the building code more restrictive than the fire code. So I guess that's more of a statement than a question. How do you? I guess this is open to anybody.
I'm going to take a pass on that. I'd have to go
Okay.
look at the statutes. I'm a little bit wary about trying to give an exacting opinion about what the current statutes say as opposed to what's being proposed by the legislature, which can be eye-raising to say the least. But I know that there has been some relaxation over, the regulatory authority of towns requiring sprinklers. I mean, generally speaking, towns can't require sprinklers unless under certain circumstances. So I'm not prepared to say that's exactly what's going on, but I wouldn't be surprised that there has been some loosening of the requirement that certain activities with multifamily occupancies may not be required to have sprinklers. That might be true, or it might actually be part of a piece of pending legislation.
All right. And yeah, I just want to make sure as yeah, Stephanie and Carol, you're welcome to jump in on any of these. And I do see another new question in the chat. And so that is what guidance is available for a planning board to know what the threshold is for plan changes that require refiling with with the deed office, i.e. utilities in a different location than originally planned.
Is this referring to a revised site plan? I'm not sure I quite understand the question.
Does that mean after a plan's been recorded?
Yeah, maybe if the person who asked the question could clarify a little bit.
Guidance is available for a planning board to know what the threshold is for plan changes required.
Yes, revised plan. There we go. Okay.
Well, to some extent, that would depend on what the site plan regs say regarding revised plans. I mean, some changes are fairly minor and wouldn't really require any action, but something like this could potentially call for a revised plan. And then it also depends on whether or not that town requires site plans to be filed with the registry, which is not a requirement. As we know, that's a local decision whether or not site plans are filed. So if they are filed and the plan changes, then that new plan would have to be filed with the registry.
Yeah. Especially if something is recorded and then there's a change after the fact for whatever reason that would be, maybe they ran into ledge and didn't expect to, so they have to go back. That's like a substantial change, in my opinion, you know, because that plan to be recorded is there forever and ever and ever. And if those utilities, you know, locations have changed, that would be, I would probably even have them go back for a public hearing for that. I mean, I would err that much on the side of caution because, you know, there's a lot of, you know, deeds may be written off of that, underground utilities, all kinds of stuff. And so then, you know, you'd have to still adhere to whatever your county registry plan requirements are. So, you know, maybe you could ask them, you know, is there a superseding process? I don't know what their policy would be for revisions of plans, you know, condominium plans or something like that, but that's a registry of deeds issue. But as far as for the town's purpose, yeah, whatever's on the face of the earth should match in the office 100% as best you can. So if utilities have changed on a recorded plan, go back, do it again, public hearing, why have they changed, that kind of thing, and then revise that plan and record that.
Although keep in mind that, as I said in my presentation, the planning board has the authority, and or the town meeting can do this, to state that certain thresholds below which you don't need revised site plan approval, that's okay, and that's probably a good thing. I think a significant change of, especially an underground utility location, that should come back to the planning board, because that might be material for not only the municipal water and sewer departments, but the electrical overhead. So I think that those kind of things probably do have to come back for perhaps a plan change. As regards just quickly about site plans, it's my understanding, and if someone out there who's doing this more frequently than me can let me know, but generally speaking, the Registry of Deeds don't want to have site plans recorded. It's just the last thing they want, and they don't really accept them, mainly because they have so many other details on them that really aren't perhaps as relevant to the registry, because the registry is more concerned with sale and division of land and recording that, as opposed to, you know, the details that go into a site plan. But so many times for a lot of towns, the site plan, if it's changed, it's just going to be a change to the plan put into a drawer at the land use office.
What I used to do is, oh, sorry, Steve, go ahead.
I know I did want to say that I did double check both the planning and zoning statutes and the state building code, and currently you can't require sprinklers in anything in 1 or 2 family dwelling units. So if the person who was asking the question, is it the case that it has now been extended to a sprinkler prohibition requiring sprinklers is being prohibited for 3 and 4 family units? I think that must be a pending a piece of legislation. I don't think that's been adopted yet. I'm sorry,
Just
Stephanie.
No, that's okay. Thanks, Steve. What we used to do for the recording of site plans, we would record the notice of decision, which had the conditions of approval on it. And, just like when you get like a deed or anything else, it was much easier. It was public record. It was in getting away from having that, that finality of recording something, we just did the paper notice of decision. So that way, it can be tracked through a title search, and it can be done that way instead of requiring a plan. And the registries were very open to that. And that was several years ago. I don't know what their space is like now, but you can still record the notice of decision in lieu of recording a plan if your community wants that finality for it and that for enforcement purposes.
And I agree 100%. Recording notices of decision is a very smart move, whether it's the planning board, the zoning board of adjustment. I think that is a very good approach.
All right. And so we've got, let's see, kind of a follow-up question to kind of continue on this line. So do planning boards require marked up as-built drawings at the end of a project construction?
Well, when you're going to sign off on the performance bond, you typically will get an as-built to show what was actually built as compared to what was proposed, and there's going to be field changes that are going to be captured in the as-built. So you definitely want to get that, especially a significant project that has a number of many elements of public improvements. You want to document where everything is and get it accurate. And so, yes, I think an as-built plan, certainly for the purpose of documenting that the work has been done according to the plan's regulation, the town's regulations, to justify release of performance bond is very highly recommended.
Yeah. And the other thing that, if you've got that in your regulations where you can do an administrative change of 10% or, a certain percentage or for whatever, and, someone has to move a sign because of a big rock now they found or something, so that I wouldn't hold up that development process with this developer moving forward or, whatever. Go ahead and do it. It's not a large percentage that would trigger going to the planning board. But then just catch up with the as-built, and then before like a CO inspection or something like that, you kind of make sure you get that as-built. And it is a good way to just kind of finalize it. And again, also good to be using for enforcement. Like that as-built should match what's out on the face of the earth. And if something happens and goes wrong, or you need to verify something and the as-built shows, 10 parking spots over here and there's only 5, on the face of the earth, then you've got some enforcement issues there. But as-built I found to be very helpful to if things come up in the construction process, to let that application go through as long as it's underneath that threshold of administrative review in your regulations, and then just catch up with an as-built at the end, and knowing that the planning board won't sign it and it has to be correct and you won't get your CO.
All right. So another question kind of popped up in the chat. This is a very general question that I think will probably remain to be seen. But the question is, how will all of the pending planning board legislation at the state affect the local planning boards?
Well, let me tell you about HB 170. That's an eye popper. This is proposing an amendment, adding a new statute, RSA 674-23-A. And paragraph 4 of that proposed statute would seemingly eviscerate planning board review and approval under RSA 676:4, because it seems to say once the planning board done its initial review, but they don't say how this review is supposed to be done, the town has 7 calendar days to adjust or alter their recommendations. Is that within the 65 days that the planning board has under 676:4 or not? Not terribly clear. And then the developer has to comply with those recommended changes within a stated period of time, which is not entirely clear either. And then the town has to accept and stamp the plans thereafter once they've been submitted by the developer. And I'm not reading a time period there. If you read it literally, because the first part of the statute says, notwithstanding any law to the contrary, this would seem to be completely eliminating the entire process we're currently following under 676:4 for review of plans for subdivision and site plan approval. It is astonishing in its potential scope of wiping out the standard timetables that are available for local action to approve subdivisions and site plans. I hope this doesn't get adopted, but it does appear to me that there's a desire to completely change the development review process with this statute. So that's, again, SB 170. And there's many more out there that are going to do as bad or worse than this particular statute. There's another one out there that's going to possibly make it almost impossible to deny approvals for development on Class 6 roads. So I would encourage anyone who's on this presentation currently is check out our legislative bulletin, and we have an inventory of the pending land use bills of which we should have very serious concerns in terms of local control.
All right, so I've got another question that I'm gonna post in the chat, unrelated to the previous topic. So this is a follow-up question from a previous presentation. Is agriculture as either a residential or non-residential use determined by a municipality's zoning ordinance versus a specific statute? In our town, within some districts, agriculture is listed as a permitted residential use.
Well, the state law says that you can't unreasonably restrict, the opportunities for agriculture and how any town might describe agriculture. I mean, there is a state definition, a statutory definition of agriculture. And even while it very often includes the dwelling unit of the farmers, it does seem a little odd to list it in a zoning ordinance as a residential use, but it's otherwise, how the town chooses to deal with that site plan review for certain things, that's not uncommon, and allowing the farmers to live on the land is also pretty common. But again, as a strictly permitted residential use does seem a little unusual.
One thing that you should, that those who are listening should be aware of, there's a presumption in RSA 674:32-A, which says if your zoning ordinance does not address agricultural uses as a use activity, and it's not explicitly described where it's permitted, then agricultural uses as defined by, there's a definition of agriculture in RSA 2134, is permitted in any zoning district. So you have to understand, if you want to confine or locate agricultural use to certain parts of town, you've got to say that in your zoning ordinance, and you've got to define what uses are allowed. If you don't, this presumption applies, and they'll be allowed in all zoning districts, any agricultural activity, which is defined in the definition of agriculture in RSA 2134-A.
All right. I'm going to add another question to the chat. So if a person buys a lot in a subdivision and wants to move the location of the site of the house to the back of the lot, do they need permission from the planning board or only to the subdivision or abutters, are there any regulations regarding this issue?
No, no, I mean, the planning board can't really tell you where to locate a house as long as it's meeting meeting the setbacks. So sometimes when you see, 4K site on the lot and, proposed house here, where the driveway is gonna go here, they're just kind of showing, preliminary like that the lot can support that. But if you run into, a situation where there's ledge or it's whatever, and there's too many trees and you want to move your house back 20 feet, no, that's not on any kind of recorded, that's not something that can be, really enforced. The only time that, even in a planned unit development, they have a building envelope, they can't tell you where to build the house, but they can tell you within this envelope. So if the plan shows that your house was 40 feet from the road, but you want it 80 feet from the road and you meet all the setbacks and everything else, then no, then you can build your house there through a building permit.
Yeah, I just to emphasize what Stephanie just said, planning boards do not have site plan review authority over the location of homes on individual lots. That's not within the planning board's authority. You're limited to site plan approval for non-residential uses or multifamily, and does not include lots used for single or two-family homes.
All right, so I've got a quick question. So would the need to improve a road accessing a subdivision fall under off-site exactions?
So there's a number of important decisions by the New Hampshire Supreme Court recognizing that sometimes a project or subdivision approval might be considered scattered and premature because the adjacent road doesn't have the carrying capacity for the traffic that will be generated to give access to the subdivision. And in those unique circumstances, yes, a project proponent can be required to pay their fair share of improvement to that adjacent public road. However, that fair share oftentimes is going to include a municipal share, because many times the road is substandard for a number of different reasons. In a part of town that road network is not being well maintained or upgraded, because there's other parts of town that are more commonly maintained and used by people traveling in that town. But this road hasn't been well maintained, but there's a need if there is going to be a project development to improve it, to allow appropriate access for the traffic that will be generated. So oftentimes in those situations is going to have to be a municipal share to that cost of doing that improvement. And then the tricky part is, well, what if the town has not scheduled the work for that road until later on in their capital improvement plan, assuming they have one? Then it becomes a tricky negotiation with the developer. Sometimes the developer has to pay the municipal share, and or the developer agrees to wait until the town has scheduled that improvement. So both elements of work, the developer's contribution and the town's, can be done simultaneously and allow the project to move forward.
All right, and we just got another question in, and again, keep them coming, folks. If you've got questions or if something comes up in something somebody says, please add it to the chat. We're here for a little while longer, and I think I've only got one more question actually in my own notes to go over, other than the one that just appeared. So yeah, please put those questions in if you have them. So if a planning board denies an application without stating whether the denial stating, I'm sorry. So if a planning board denies an application without stating whether the denial is with or without prejudice, does that leave the matter open for interpretation?
Don't do that. Right? Okay, just
Gonna
don't
let
do that.
Steve jump in first.
Please. If you're going to deny it, you got to deny it with reasons. You got to state the reasons, or otherwise you're going to get reversed automatically on appeal. If you're going to deny it without prejudice, you got to say that. So don't do this. You either deny it without prejudice or deny it with reasons and state the reasons. And the reasons should be supported by evidence in the record. There's only two ways to do this.
Hey, Jordan, can I take control and back up to one of my slides?
Yes, absolutely.
Okay, alrighty. Because Steve, we had some discussion, I gotta put my glasses on. We had some discussion about, I took some language about for duty to assist from the planning board.
That was actually going to be my next.
Okay.
I'll put this in the chat as well. It's kind of a long
And
one about who the citizen who is a citizen, what's a citizen.
It generated a lot of discussion in the chat. And
Mhm.
I said, well, maybe we can have Steve's. Let me see. Oh, wait a minute. I think I just passed it. Yeah.
Yeah, and
Steve,
I
can you see that, Steve?
Yep.
Practice pointer duty to assist.
Right. Okay. Yep. Duty to assist.
So
Richmond
there was,
versus the city of Concord.
oh, was that the case?
Yes.
Yeah. So well, going through my presentation, there was a lot of the word that kind of started the chatter was municipalities have an obligation to provide assistance to all their citizens. And so it started some chat about who's a citizen, what counts as a citizen. There's a huge difference between a resident, a landowner, and a citizen. The terms aren't interchangeable. So I just kind of wanted to get your legal expertise on having more knowledge and background of that case and the Supreme Court saying to municipalities, you have a duty to assist your citizens and what that kind of means.
So I guess I would say this without rereading the Richmond versus City of Concord case. My recollection is Richmond was an out-of-state corporation trying to develop some property in the city of Concord, and there was some debate about whether they do historic development improvement or something. I can't remember the details. They weren't even a natural citizen; they were a corporate citizen. I don't think the Supreme Court ever intended to say, we can treat this out-of-town person from Massachusetts who's making a subdivision application different from Farmer Brown who's lived in town all of his life. There is no possible way the court would ever have conceptualized we would treat them differently. I think the object here is anyone who comes to your board seeking approval, you have a duty to assist them. It does exist. And that can be anyone from out of state, it could be an out of state corporation, and it could be someone who's lived here 50 years. And ideally, they're treated the same. You're not going to have unequal treatment for different categories of people, resident, non-resident, out of state corporation. That makes no sense whatsoever. So I think your duty is to treat everyone fairly and to offer the hand of assistance when appropriate to persons who apply to land use boards, planning boards, and zoning boards of adjustment.
Absolutely. Thank you, Steve. Appreciate that.
Excellent. Yeah, I appreciate that. That was going back and forth quite a bit. Let's see, to kind of go back a little bit, we had a couple questions pop in right when we started talking about, kind of the citizen question. Let's see. So if a planning board denies an application, oh wait, I'm sorry, we already did that one. Let's see. What about serial subdivisions that over time amount to what would be categorized as a major subdivision?
So I have seen some subdivision regulations that include language that set some parameters around that. I don't know, Stephanie or Stephen, if you have as well, but for example, someone comes in for a 2-lot subdivision, that would be minor, but 2 years later, they come in for another 2 lots. So I've seen regulations that say if that sort of thing happens within a designated time period, then that next subdivision is going to be treated as a major subdivision, and they would be asking for all of that additional information that they wouldn't ask for with the minor.
So the way that we handled that in my planning board, we had a regulation that required the developer who had, let's say, 100-acre lot, and they were developing only a small portion, 20 acres. We would make them do a preliminary layout. And that was really to be sure that we would be able to manage future subdivision of a 100-acre parcel after the 20 acres been approved, because we have to then be thinking ahead. How is the road network and the 20-acre original subdivision going to connect to other roads in town, and where those connections are going to occur? I remember a couple of times where we were doing an approval and we'd say, wait a minute, we see the entire parcel. We see that there's a road up on this section of the potential subdivision in the future. So we would want to have a preliminary layout. We don't want them to develop the project in a way that's going to have backland that could never be developed or never be connected to other parts of the town's road network. So we handled that through, requiring some kind of preliminary layout that we would use as a template. I'm not so sure the major minor part, major being maybe more intensive examination, different layers of plan content, different types of reports from experts. We were more concerned about making sure the development and really intending to help the property owner think ahead. If you got 100 acres and you're just doing 20 acres now, think ahead of what's going to happen in the future. Don't foreclose all the possibilities that may be appropriate for this parcel in the future. So that's kind of how we address the issue.
All right. All right, excellent. Let's see. So, got another question that popped up in the chat. If someone buys a piece of land and wants to build a single-family home on that piece of land, what would that process look like for the planning board? It wouldn't be a subdivision or a site plan, from what I learned today. Would they come to the board with plans just to show compliance with zoning, setback, size, etc.?
They don't go to the planning board at all. They just get a
Right.
building permit. I'm
Building
sorry, we're
permit,
talking over each other. Sorry.
Right.
Yeah, they just get a building permit. They don't have to go to the planning board.
All right. Yeah, that was an easier question. Let's see. And then we've got another one. Should every notice of decision contain a finding of fact section?
Yes. Yes, absolutely.
Indeed.
All right.
Yes, believe me, what I see, pieces that come all the way to the Housing Appeals Board because boards still aren't doing findings of fact. So no matter how many times we can issue a decision that says the only reason why we're sending this back to you because you didn't do a findings of fact, we still have cases that don't do findings of fact. So I would encourage all of your communities to work with your municipal attorneys and get a system, a template, or whatever. Just kind of like what you've probably heard from different sessions as well as in mine. You can't just say, we deny this because this meets the variance criteria, because you have to give your reasons for your decisions, whether for or against, that give the applicant direction and that comply with 673. What is it, Steve? 673-1. 673.
No,
I just had it.
673:1. I think it's paragraph 3 now.
3 or 4, yeah. So can't stress that enough. You've got to do your findings of fact. You've got to work with your town attorneys to get them to be complete.
Excellent. All right. And then I got one more question. Is there a difference between a private road and an approved private road? And if so, what makes it approved?
Okay, well, let's be clear. There's a road, and then there are public roads and there are private roads. So let's talk about roads. So roads are either class 4 in towns, which is a road that's been designated as subject to municipal maintenance by the Department of Transportation. Class 4, class 5, the standard town roads, and class 6, which are unmaintained town roads. Everything else, if it's not been approved as a public right-of-way, at some point in the past, might be a private road. I mean, typically private roads come about mainly because there's a development that has been approved and the road was never laid out and constructed according to planning board specifications. It's shown as a platted street on a plan. It's recorded at the registry of deeds, but for whatever reason, it was never constructed according to plan. And it turns into, by operation of law, a right of anyone who bought property incident to that subdivision. They have a right to ingress and egress, and it creates, in effect, a private road. I think, and also it could be the case that a private road can come into existence if a town discontinues. A town meeting can vote to totally discontinue municipal interest in an old road, a road that existed maybe from the 19th century. The town votes to discontinue it. That could then become a private road, but typically what happens when you completely discontinue a road is the persons who own on either side of that discontinued road then become the owners typically to the center line. But then there's also a concept that recognizes everyone who has property on that previously public road, now discontinued, has an implied easement for ingress and egress for use of that road. And that's kind of often the time when this private road came into existence, through the fact that at some point in time there was a public road and it was discontinued by town vote. I don't think it is prudent, generally speaking, for towns to approve subdivisions with private roads in them. Because what's going to happen, I guarantee it, when those homeowners don't want to maintain that road anymore, they're going to petition the town meeting to lay it out as a town road. But that does happen occasionally, where planning boards will approve a subdivision with a private road. So that is also a possibility as a way a private road could come into existence.
Just to kind of, piggyback on that too, is when you're talking about a subdivision that they shouldn't approve it with a private road. All roads in town, whether they're private or public or whatever, they should be built to town standards, just for the scenario that Steve mentioned. And you may hear grumblings of why you have to build a road to town standards, because if the town does eventually take that over, then it needs to be able to handle a school bus and an ambulance and all those kinds of things. So there's a method to the madness for some of these things, as far as building to town standards and why they're private and why it's not private. So just kind of a little bit of just a practice pointer, that whether it's public at the beginning, private at the beginning, and the town will take it over in 2 to 3 years, that road still needs to be built to town standards.
All right. Well, it's actually our last question, unless anybody else has anything else they'd like to put in the chat, or if Stephanie, Carol, or Steve, if you guys have any closing remarks, I might. Oh, here we go. We got one more. Let's see. What? Oh, two more. Okay. Let's see. What about a proposed private road in a subdivision that will become an HOA?
Well, okay, it's still a private road, and you're going to have an HOA, but it's not a public road. And so you have to develop complex little interactions between the municipality of access, maintenance, operation. Just because you have an HOA doesn't give it some kind of, general blessing. Oh, well, this is an exception to the public road requirement, 67441. But I suppose an HOA could be there, and that would be good to make sure that the road is going to be maintained if all of these lots get permission, as they're required to do, to build a house on something other than a class 5 road. They'd have to have that permission under 67441.
And that just goes along, and no, I did not just say it is a law that all roads must be built to certain standards. It's that just example with the subdivision become an HOA. If you're gonna have a private road and have the road just maintained by HOA, what's to guarantee that a school bus, an ambulance, a fire truck, a police car can't access and get down that road, or turn around in that road, or come and plow that road for, even if it's not a town plow? So the point is that whether the road is private or public, the developer's coming in and you're going to have a homeowners association who's going to maintain the road, that road should still be built to town standards for safety and access. And if in a situation where the town does take the road over, there's situations where the developer will maintain a road for like 2 winters, put a top coat on it, do something like that, and then the town takes it over. Well, that road needs to be built to town standards. within your regulations.
Yeah, and roads are quite expensive as well. I will add. So make sure you know what you're getting into. All right, and then last question: what if another country wanted to buy up a huge amount of land in a town? Would there be any restrictions on that?
I'm not aware of any law that prohibits people who are not citizens of the state of New Hampshire, including corporate citizens, from buying land. There are some countries that have such rules. I know Canada had such a rule. They were concerned about large purchases of property in the city of Vancouver over on the west coast of Canada, but I'm not aware of any New Hampshire statute that would regulate the acquisition of real estate by out of foreign corporations, that is, corporations that exist outside of the state of the United States.
And then kind of going back to the private roads, somebody made kind of a statement question. A 5.7 acre private road in a subdivision, property owners do not own the to the center. This road is listed as a lot. So who owns it?
Boy, that sounds like a very particularized question arising out of a set of facts and circumstances and the needing the review of some records to determine how to answer the question. I know that was common, especially during the go-go 80s and 90s for development, where the roadbed would be a separate parcel of land and would be conveyed separately by the developer, maybe to an HOA or maybe to a municipality if it was going to be turned into a town road. So how this normal way in which the abandonment or the discontinuance of a public road and the abutters then owning to the center line does somewhat depend upon the record title and how the land was conveyed by the original owner to the people who owned parcels along the side of the road. So it's difficult to answer that question without knowing a lot more about how the lots came into existence, how this particular road lot came into existence, and who it was conveyed to. So I'd be a little hesitant to give a statement as to precisely what that means in this context.
Let's see. This is kind of a question. Landlocked right of way to get to it is the frontage. Not exactly sure. There's a question there. It's not quite clear if you guys can see it in the chat. Landlocked right of way to get to it is the frontage.
Well,
So I don't know if they're talking about a flag lot or.
There is a provision in the Class 6 road statute, the way I call it. It's RSA 674-41. So just understand what that statute's all about. It's intended to prevent scattered and premature development on substandard road. That's really the main purpose. And you've got to have frontage on a class 5 road or have an exception and permission to build on something other than a class 5 road from the select board. Now, there is a provision in that statute that says the road giving access to the lot cannot be an easement. You can't claim the right to have access to an adjacent class 6 road or class 5 road or private road for that matter if you have no frontage. That is, your lot does not connect directly and is connected to that road system. And that's part of it's paragraph Roman 3 of 674-41. So if you don't have that, you can't even get permission to build, nor can you get permission from the select board to build. So access to the adjacent road by a right-of-way is completely insufficient under 674-41 unless you get a special variance granted by the local ZBA, and that's under 674-41 Roman 2.
A private road in my neighborhood, and and there's signs all around it say, private road, keep out, no trespassing. I didn't really think that that was legal to do, as private road kind of mostly deals with maintenance, not like access, right? I can walk my dog down a private road, can I? Or no?
Maybe not. Uh, you know, uh, I, I, I would say that the people who own that private road have the right to permit what kind of ingress and egress they're allowed to willing to accept. I mean, just understand that the viatic rights, the rights that you have to use public easements, viatic easements, that only attaches to public roads. So the right to be a pedestrian on a public road, class 6, class 5, class 4, that only attaches to a public road. So that access to that private road can be controlled by the property owners, and they may have the ability to exclude others because they're not required to accept the public on their private road. And it may depend upon the nature of the agreement they had with the town to be allowed to build on the private road. And are they required to permit access? I would assume they want access from public safety vehicles, but it's going to depend upon the written agreement they have with the municipality. So they may not be required to let you walk your dog down that private road, Stephanie. That may be something they can just prohibit. There was a case a number of years ago, I'll just mention it real quick, where there was a dispute between people who were sunbathing on a road that was adjacent to a lake. And that was an old discontinued right-of-way, town right-of-way. And the people who were adjacent to that old discontinued public right-of-way argued successfully that whenever we allowed or required to allow viatic use of that road, that did not include sunbathing. That included using the road for viatic purposes, ingress, egress, pedestrians, horse riding, but it didn't include sunbathing. And the sunbathers were told to quit it. They couldn't use that road anymore. So there's that case out there. There's a case from the town of Gilmanton.
To go to the Supreme Court?
Yes, Supreme
Yeah.
Court case.
Wow. All right. Well, I'm not seeing any new questions coming in. We've got a little more than 15 minutes, until the end of the session. Yeah, I don't know. Yeah, like I said before, Stephanie, Carol, Stephen, do you have any, or Steve, do you have any other any closing thoughts or questions you think may not have gotten answered, or things that weren't covered?
Well, the only thing I would just want to emphasize, and that's why I always lead off my presentations with the duty to assist. Towns have to work with people, and they've got to be reasonably working with people. They've got to assist them where they're getting lost in the what can seem like a dense forest of regulations. So I think that's really important. And, perhaps some of the efforts by the legislature this year and in prior years to carve back local control, I do believe it's called local control, is due to some municipalities being less than helpful to their citizenry. And that's going to be including people who are from out of town. So I just do believe that's a paramount thing to keep in mind if you're a member of a land use board. And you're not there just to say no. You're there to help the person achieve their desire to use their property reasonably. And I would just emphasize that as a code of ethics that municipal land use board members should abide by.
Well said.
Yeah, yeah, I totally agree with that, Steve. And it's this. I never thought when working in the, as a planner and being on the planning board and being technical assistant to a planning board and learning from the great minds like Steve Buckley and Tim Bates and so on, and Walter Mitchell, to make sure that, you're telling your boards that your minutes are complete and that your decisions are complete and say what you mean, and you can't enforce intent. And it goes along with also not being the type of board that because you don't like something, you're going to drag something out, or you really like something and you're going to approve it right away. You have a duty as a board member you have to make the tough decisions. And if an application that meets the requirements, that meets your regulations, then an application should be going through the process unless there's a glaring reason to deny it for whatever the board says. But that goes along the lines of your duty to assist. You have to make the decisions of what applications come in front of you. The people who voted you there, they've elected you there, you were appointed there. The people aren't lined up around town hall to join the planning board. Woohoo, sounds like tons of fun. So you have a big responsibility, and your responsibility deals with making decisions. And your responsibility also deals with, voting, not abstaining from something. You were put there to vote, make a decision, and make the tough decisions. And as what I have seen on the Housing Appeals Board in situations that we have, is that it really is important to have the municipality and the board be very clear with their conditions of approval and be very clear with their findings of fact. And I never, would think that you could tell from a certified record what a board was thinking or what a board was doing. And you can tell that there are municipalities out there that aren't doing an honest duty to assist an applicant through the process. And so, I would just, again, agree with Steve and Carol as much as they have already said it. But if you don't like an application that comes through, or you don't like a design of an application, the remedy is not to take it out on the applicant. The remedy is to look at your own regulations, which you can amend subdivision and site plan regulations without going to town meeting. So if you don't like how wide a road is, if you don't like that there's not enough street trees, and this Dunkin' Donuts comes in and they only had to plant 2 trees, you shouldn't deny Dunkin' Donuts because they only had to plant 2 trees, because they've met your regulations. The remedy is to change your regulations for what you want your community to look like, what you want Dunkin' Donuts and Aroma Joe's to look like in your community. Then make your regulations have that. It's kind of a fine line, but it's an important line, because where you're going to start to get in trouble, where it can be obvious in the record that an application met all the requirements and proved their case, and you denied it because you didn't like it. That's where you can start to get into trouble.
All right. Excellent. I just wanted to chime in again. I've just put the in the chat the website for this presentation with all of us. So the slides are currently available right now, so you can open those up, and there's links in those slides that, links to a lot of the topics that everyone was talking about. They're also available for the zoning board and the housing and historic preservation tracts as well. All of these are going to be available on YouTube. I just put the YouTube link in the chat as well if you want to, save that to your browser or return to it in the future. That would be that'd be good. We've already got some good presentations on there. The most recent one we did was congratulations, you're a board member, now what? And so that's for some of the newbies that I've seen in the chat who were saying they're just getting started. That might be a good place to start as well. And yeah, once again, this will all be available hopefully sometime next week. On YouTube as well. But yeah, thank you all so much for attending and asking such great questions. Thank you again to all of the presenters. Steve, thank you once again. You're always fantastic. Carol and Stephanie, of course. Yeah, this was a great year. Thanks everyone, and yeah, until next time.
Thank you.
Okay, thank you.
You.